Good afternoon, Your Honor. In a moment, I will read the officer in charge, or the OIC's, report, including the call and the events leading up to the arrival of the homeowner, the plaintiff. The time is 13:17 in the afternoon when crews were dispatched to 614 Mays Street on a first alarm residential structure fire assignment. This assignment consisted of 2 engines, 1 truck, 1 rescue, and 1 battalion chief. Shortly thereafter dispatch, the first arriving company reported seeing dense black smoke pushing from the eaves and roof vents of the residence. Standard fireground operations commenced, at this point including the first 2 engine company forcing the front door for entry. Immediately following, crews then stretched hand lines into the interior space for quick search and extinguishment of the fire. Interior operating crews quickly found fire in an area specifically around the TV in the living room. Reportedly, the crews stated that the rest of the structure had light smoke conditions and good visibility, but heavy to moderate smoke conditions in the living room, with near zero visibility noted. Shortly thereafter, search and rescue operations were abandoned because the family arrived saying that they had just returned home from the store and no one else was in the structure. After the extinguishment was completed, the fire was declared under control, and the lieutenant began working on his paperwork, while crew members on the scene began repacking hose and tools. During the repacking of the truck for service, dispatch issued a second full alarm assignment for a residential structure fire with children trapped just 3 blocks away. Crews quickly finished loading the hose and responded to the fire to carry out their obligation to do so, leaving the scene at 614 Mays Street unsecured. Your Honor, the accusations that there is any wrongdoing in this case is just baffling. When considering the context of what happened, these men and women heard a second fire go out, and they were bound by law to respond within a reasonable amount of time, not to mention the fact there were also kids reported to be trapped. Taken into consideration, wouldn't you not only want them to respond, but demand that they do if they were your kids? I would have. Your Honor, next, you will now hear the report from the fire investigator, the defendant. Upon my arrival, crews had fully extinguished the fire, with them quickly responding to another alarm per request of dispatch with possible entrapment involving children. Also noted, the homeowners were not present when I arrived. As I began my investigation, I take photographs of the exterior for file notes. What was burned, what was melted, and what was broken. I made my way inside and continued taking pictures. Again, what was burned, what was melted, and what was broken. While examining the evidence, I note personal items that appear to be missing, and the house seems staged with old furniture and a broken TV. Upon further investigation, I note an unidentifiable melted object behind the TV. I will now show Exhibit A. This is the unidentifiable object found behind the TV. As I collected the melted object, I noticed a pour pattern towards the kitchen. I will now show Exhibit B. In this picture, you will notice medium burn patterns, heavy burn patterns, and splash patterns from the TV into the kitchen. I collected samples and then advised the appropriate authorities that this is in line with arson and charges will be filed. End report. As my client, the defendant, was finishing his appropriate paperwork, the homeowners, the plaintiffs, returned back home, accompanied by their lawyer. The defendant was accused of entering the house without permission, and any and all evidence collected must be suppressed due to the chain of custody. Myself, representing the defendant, states that evidence obtained was in violation of the homeowner's constitutional rights, including the Fourth Amendment right against the warrantless search and seizure. Your Honor, as discovered in this case I have here in my hand, Michigan versus Tyler, this evidence should be allowed as all actions taken were within normal operating guidelines, with the exception not maintaining continuous, uninterrupted scene security, which only happened due to the circumstances that unfolded that day. The firefighters on scene were just a couple blocks away from a second structure fire, and this one had kids reportedly trapped. They were absolutely doing the right thing in deciding to respond to a civilly sworn duty to protect those trapped and extinguish the fire, and to think that even with the evidence gathered, this would possibly be dismissed is unthinkable. As stated in Michigan versus Tyler, firemen have a reasonable amount of time to investigate the causation of the fire. I would argue that the premise and intent of the search and investigation in this case were well within terminology. Your Honor, we believe it is well within the law and in accordance with the defendant's constitutional rights to allow the evidence for the jury to have a complete and comprehensive understanding of the charge in this case. Thank you.